Hi, I'm Debbie Moraes, and this is Legal Matters, the program designed to cover some of the critical and controversial issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that affect your work and home life. In our last topic, we were discussing unemployment insurance benefits, some of the appeals, the legal aspects, as well as those practical things. And as always, we ask our viewers to email us questions. So we're going to have our legal experts address that first, and later today, or today, our topic is going to be the credit reform, such as it is. So first, we'd like to introduce Jackie Grasso and David Bizarre from Odette Bizarre Cadero Grasso Law Firm in East Providence. Again, welcome.
Thank you.
Okay, the question about the unemployment benefits are this. If you've been separated from your job, as the saying goes, what do you do about your health benefits if you had them when you were employed or if you didn't have them in Massachusetts and Rhode Island?
I'll take a stab at the
Sure.
math. If you're separated involuntarily, let's call it a layoff, I think under the stimulus plan you're allowed to collect your benefits at a rate of 65% of the normal premium. So basically you can stay on stay on the benefits through COBRA, but as long as you're collecting unemployment, you pay 65% of what that premium would have been had that benefit not been available. In Massachusetts, it's the same thing. However, or even in Rhode Island, if you're voluntarily separated from your job, or if you're fired, everybody has to have the right to stay on benefits through COBRA. Okay, and again, I think they keep you on by law for 18 months. If you're able to collect, you go to that 65% figure that I told you about. If that doesn't apply or the benefits run out, in Mass you can opt to go on Mass Health, which is the public health plan. It's mandatory anyway. If you make under a certain amount of money on benefits, for instance, I think there's a cutoff of $13,000. If you make under that on an annual basis, then you pay the state somewhere around $42 a month. It's under $50. It's on a sliding scale, so the more you make, the more you'd have to pay into the state.
And it's the same in Rhode Island, except we have a program called Right Care, which allows you to get coverage if you're in that same general vicinity of income that Jackie talked about from Massachusetts, and don't otherwise qualify for COBRA benefits, which is a federal statute that says you're entitled to keep your benefits after you've been separated from work, medical benefits.
I'm not sure about this, but I think maybe with Right Care you have to have minor children.
Yeah, that's correct.
I think in Rhode Island, I'm not sure about that, but in Mass, it doesn't make a difference either way.
With or without children,
That's
family
right.
plan
Yeah.
might be a husband, wife, and
That's
it's still
right.
applicable.
Yeah, because it used to be Mass Health, which would be similar to Right Care, which is somewhat a form of a welfare benefit. But now, because of the public health plan in Massachusetts, anybody can buy into it.
Good to know. Thank you. So today, as of February 22nd, there is a credit reform bill in place. So essentially, with that law taking place, it's meant to keep banks from employing those tactics that put those borrowers in deep debt. I understand that it's supposed to be consumer-friendly. It is supposed to be consumer-friendly, and that means it's designed to save you money sometime, and in many ways it does work, but of course, caveat emptor, buyer beware. So with our experts, we thought it would be a good idea to review some of those practices and some of the things that you can avoid, either racking up additional charges, fees, penalties, and things that you really shouldn't have to incur. So let's start with this. With those changes that have taken place, help us decipher them. Best place to start, what's the outline of the changes?
First and foremost, the Credit Card Reform Act does not apply to business or corporate cards, so it's strictly consumer. Some of the changes, no arbitrary increase of interest rate. So many of us have been a victim of the bait and switch. You're going to get a fixed interest for this amount of months, and then lo and behold, in the mail comes a letter that says your interest rate has to be increased because of the credit industry, and which is exactly what credit card industry did before this act took effect, because now they can't do that. If they attempt to increase your interest rate, you have 45 day, they have to give you at least a 45-day notice, okay? You have the right to cancel the card if you don't want to pay that interest rate, and at the same time, the credit card company cannot charge you any interest on that. If you can't, I'm sorry, if you cancel the card, they can't put a negative credit rating in your credit bureau. Because it doesn't really look that good on credit when you're canceling cards. So it would just see, on your credit bureau, it would say, closed by consumer request. Well, those are little things that banks look for in order to reduce your credit score, whatever that is. I don't even know how you can define a credit score today.
Right. Well, it's interesting. As you stated, the credit card Cardholders' Bill of Rights, as it's called, is designed to protect consumers, and that's what it was designed by Congress to do. But as Jackie was saying, you have to be very careful as you go forward with this, because there are ways that credit card companies can still charge fees on late fees, on over the limit. You have a certain credit limit that you're allowed to use. If you're over that, they can charge fees for those things. So I think it's more and more important today to read the inserts and everything that's on your bill as you get it each month to make sure you're aware of what the bank is doing and understand what your rights are.
That 2-point or 4-point mouse type that's on pages 2 through 12.
That's interesting because that's a change in the law, because now it can't be miniature print where you need a telescope almost to see it, or a magnifying glass. It has to be larger print and readable font. So that's another little byproduct of this law.
Many companies will let you get your statements by email these days, online, electronic bill statements, which if they are small, you can make bigger yourself on your computer.
True. And it's a good point online. The credit card companies now are required to post on the internet a copy of the cardholder agreement. Previously, you only saw your cardholder agreement when it came in the mail with your credit card.
And I guess that means those who are astute enough to do some comparison, it's easier to do that if you can have 3 or 4 different credit card terms and agreements so that they can compare and make a better choice. Yeah. Now back to the issue that you were mentioning about the promotion, what might be a promotional announcement. I understand from this, as a result of this law that's been changed, you may have fewer companies issuing promotional rates because I think, is there 6 months or a year that they have to keep whatever they are proffering as a swell introductory rate to get you to sign on? I mean, is there some sort of parameter that says once, whatever they offered, 3% introductory, they always had those, but do they are they
the teaser rates?
Yes, the teaser rate. They're obliged to keep that for 6 months now, or some
They're
term?
obliged to keep it unless you default on the card. So that's the unless, the but, however you want to call it. But what they can't do now is if you are paying on time, and you have been consistently for several months, then they can't just up your interest rate. If they, and again, if they do that to you, they have to give you 45 days advance notice. You have to have the right to cancel the card, and they cannot put any negative credit rating in your credit bureau.
I understand they call that opt-in or opt-out.
Yeah.
If you decide to opt out, then it's not going against your record and you can cancel whatever.
That's right. That's right.
Now, apart from the rate structure that they're supposed to be more disclosive of, which should help consumers, there's also an issue apart from rates, which ends up being called rates versus fees, and how they tally both of those. Can you explain a little bit about what a consumer should watch out for when they're reviewing all of these new terms and agreements, whether it's online or in the 42-page document?
More and more, I think you're going to see credit card companies and banks in particular relying on those fees to increase their income and keep making the money that they want to make. So you have to be very careful and follow along, and as I said, read the statements to see what the rules are. They can charge a fee if you're late still. They can still charge you a fee if you're over your credit limit. And those fees can be significant. I'm not sure if this bill addressed it, but I have clients who, with the debit cards, you know, where they go to the ATMs and they buy a $10 coffee